Hi, my name is Vincent Piazza. I'm a Social Security disability lawyer from Baltimore, Maryland. And today what I'd like to do is discuss with you both steps 4 and 5 of sequential evaluation. Step 4 is the ability to perform past relevant work. Step 5 is the ability to perform other work. Now, in prior videos, what we discussed was the first 3 steps of sequential evaluation, which are basically designed to weed out individuals who are actually working, individuals who have very insignificant medical problems, individuals who have extremely significant medical problems, and then as we move into step 4, sequential evaluation, step 4 is used to actually weed out individuals who can return to the kind of work they did in the past. Now, past relevant work is work which is done in the last 15 years, and it was also work that was done at a substantial gainful activity level. Now, at step 4, it's a 3-part analysis. First thing that Social Security must determine is what are the physical and mental demands of past relevant work. What are the strength requirements? What are the endurance requirements? What are the manipulative ability requirements? Now, how an administrative law judge would actually determine that is either via the claimant's testimony, the Dictionary of Occupational Titles, or even the vocational expert's testimony will help them elicit information as to what the past physical and mental demands of past relevant work were. Secondly, they need to make a current assessment as to what the person's physical and mental RFC is now. So what can an individual do either physically or emotionally, notwithstanding their various impairments? And then simply, you just make a comparison between the two. And that's how Social Security actually determines whether or not someone can return to past relevant work. Assuming they can't return to past relevant work, Social Security would then move on to step 5 of sequential evaluation, which is the ability to perform other work. Now, before you can actually launch into an analysis of other work, you need to make a determination as to whether or not the impairment you're looking at, or the claimant that you're looking at, whether or not their impairments are strictly exertional in nature, meaning that they only affect the ability, let's say, to sit or stand or lift. If they are only exertional limitations, then Social Security has what are called the medical vocational guidelines. And those are a set of rules and regulations which actually dictate the outcome of a particular case, meaning whether or not someone is to be allowed or whether or not someone's case is to be denied. So let's take an example. Let's assume we have an individual who's age 52. They're limited to a sedentary exertion, unable to return to past relevant work, who's both light and unskilled. Social Security's medical vocational guidelines would dictate that that case must be allowed. Whereas if we have an individual who's age 52, now limited to a light exertional capacity, they can't return to their past relevant work, which is medium and unskilled. Once again, Social Security's medical vocational guidelines would dictate this time a denial of benefits. So again, medical vocational guidelines can only be used if we're dealing with purely exertional limitations. If an individual has both exertional and non-exertional limitations, then an administrative law judge will be required to have what's called vocational expert testimony. So in our prior example, if the individual had, let's say, significant depression or anxiety, in addition to their physical impairments, medical vocational guidelines could not be used. And a judge would now be required to craft various hypothetical questions to a vocational expert for purposes of identifying or not identifying other work. The way that normally goes is a judge would say to the vocational expert, assuming Mr. or Mrs. Vocational Expert, you have an individual of a particular age, education, and past relevant work. These are their various exertional limitations. These are their various non-exertional limitations. At that point, the vocational expert would then have to either identify or not identify other work the claimant could perform. So let's kind of recap. Step 4 is the ability to perform past relevant work, which is work that was done in the last 15 years at a substantial gainful activity level. It's a 3-part analysis. Determine what the physical and mental demands of past work were, make an assessment of what the person can actually do now, physically or emotionally, and then just compare the two. Step 5, the ability to perform other work can only be done in one of two ways. If we're dealing with purely exertional limitations, then you can directly apply what are called the medical vocational guidelines. If there's both exertional and non-exertional limitations, then an administrative law judge is required to elicit a vocational expert testimony. So that's steps 4 and 5 of sequential evaluation. Thank you for your time and attention.